And the question before us, Mr. Williams, you're recognized for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Plaskett, and members of the subcommittee. Thank you very much for inviting me to testify today. My name is Elliot Williams, and over the course of 15 years, I had the honor of serving in all three branches of our government. Across that time, I worked as both a career prosecutor and a senior appointee, as both a rank-and-file employee and in senior management, and in both Republican and Democratic administrations. For a major portion of my time in government, I served in roles tied directly to the relationship between the executive and legislative branches of government. I served as counsel to the Senate Judiciary Committee across the building, or across the courtyard, and helped run legislative affairs at both the United States Department of Justice and the United States Customs and Immigration Enforcement, or ICE. And I know that I'm here today speaking in my personal capacity and not on behalf of any employer. Now, having sat in the seats of the very staff behind you alongside some of the very people who are still here today, as well as in the role of the executive branch employee or official responding to your requests, I can say that each institution's interests are critically important to creating a healthy, functioning democracy. When they collide, it is crucial to recognize that our institutions are best served by reaching compromises or accommodations, and we're going to hear that word again in a moment, that protect the core interests of each branch of government. Congressional oversight, the reviewing or monitoring or supervision of federal agencies and activities, is essential to good government. It helps ensure that officials who hold the public trust apply laws fairly and spend their funds wisely, our funds wisely. It uncovers abuse and uproots waste. It encourages efficiency and fosters transparency. Now, this is a two-way street where Congress ends up better informed when making its legislative decisions, and the executive branch is in a better position to carry out its enforcement of our laws. Now, there is a natural and perfectly reasonable push and pull of constitutional and legal interests when two branches of governments interact. But too much pushing or pulling from either side poorly serves the American people and does not serve the work of the American people. Now, each branch of government, and I mean the legislative and executive, have a tremendous amount to lose and a lot to gain in the process. It's in the interest of people at both ends of Pennsylvania Avenue and across the country that our institutions and our democracy function properly. Now, Congress and the Justice Department, both where I worked for a long time, have recognized this principle. The Justice Department has attempted throughout the years to balance satisfying legitimate legislative interests with protecting the executive branch's confidentiality interests. An obvious example arises when disclosure of case materials from an open criminal case or civil case might be disclosed to the public or to Congress. There might be a significant public interest in the Justice Department's efforts to protect those materials. Likewise, Congress has a very long history of engaging in responsible oversight, and bipartisan oversight at that matter, of the executive branch. This means reaching accommodations that have regularly included narrowing requests for information, limiting access to information that's provided by the executive branch, or even at times delaying a congressional investigation until the work of the Justice Department in the form of prosecutions or declinations are completed. For instance, here's an example. In the early 2000s, the House Oversight Committee wanted to obtain documents from Special Counsel Patrick Fitzgerald's investigation into the leak of the covert identity of CIA officer Valerie Plame. They consulted, this is the committee, the Oversight Committee, consulted with the Special Counsel and agreed to delay receiving information until after the end of the litigation or after the investigation and litigation. Even then, the chair of the committee worked closely with the special counsel to narrow his requests that the special counsel agreed would not infringe on his prosecutorial independence or intrude upon grand jury secrecy, which, as many of you know, is protected by law, under the law. Both sides here, Congress and the executive branch of the Justice Department, had interests. They both balanced them for the good of democracy, the health of our institutions, and transparency for the American people. Now, as with any process of negotiation, not every party will always receive what they seek to recover, nor will they be able to protect every bit of information they wish to shield. That is not a bad thing, and we will talk about that over the course of the day. Needless to say, thank you again for inviting me to testify, and I look forward to answering any questions you might have.
Thank you, Mr. Williams. Ms. Parker, you're recognized for 5 minutes. Ms. Parker, hit that button. There you go. Thank you.
Chairman